pleasant, good afternoon to one and all. Welcome to Law Seeko's thorough newspaper analysis for 3rd of Feb 2024. Now, let us start with the today's agenda of the day. We'll be speaking about the editorial section related to Aligarh Muslim University minority status case, 3 key legal issues argued before the Supreme Court, which we are discussing from the Indian Express. Then we'll be discussing some interesting news update and the legal news update of the day. Now, starting with the context of this particular editorial, Supreme Court has concluded the hearings in the case of Aligarh Muslim University can claim minority status under Article 30 of the Constitution or not. So it was a 7 judges bench will also decide if the decision in S. Aziz Basha versus Union of India, where the court held that Aligarh Muslim University was not a minority institution, should be overruled. So the bench is led by Honorable Chief Justice D.Y. Chandrachud, which heard the arguments for 8 full days between January 10 to February 1st before reserving the judgment in the case. So now let us decide the 3 major issues before the Honorable Supreme Court. Now, effect of the statute on minority status. So what the background is all about, that the Article 30 subclause 1 of the Constitution, which states that all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. So in the year 1967, Aziz Basha versus Union of India, Supreme Court held that AMU was established through the enactment of law, and this means the AMU does not qualify the minority status as it was not established by the Muslim community. Now, what the petitioners say is that there is a contradiction in the Aziz Basha decision in which the Apex Court held that in order for degrees from the university to be valid, the university would have to be recognized by the statute. However, the court also held that recognition by a statute would strip AMU on its minority status. Now, what respondent says that Solicitor General Tushar Mehta argued that AMU surrender its minority status to the British government and choose to be loyalist institution as opposed to nationalist institution, which resisted and denounced the British government. The surrender of rights was recognized in Aziz Basha case, and this is the respondent contention. Now, the second issue here in the case is how does the administration of AMU impact its minority status? So, petitioner, Senior Advocate Kapil Sibal, argued that it does not matter who is in charge of administration in the minority institution, even if the members of administrations are not members of the minority community. Now, the respondent in this particular issue say that the administration must be considered in its case as the British government had ultimate control of the university through Lord Rector when AMU was first established. Though the court of the university handled the day-to-day administration, the decisions of this court were subject to the approval of Lord Rector. And the third major issue is that should 1981 amendment be considered in this case? So 1981 amendment to the AMU Act introduced multiple provisions stating that the university was established by Muslim community and explicitly highlighted the need to promote the cultural and educational advancements of Muslims in India. They also held that 1981 amendment was enacted to override the Aziz Basha decision. This ruling was challenged at the Supreme Court and was referred to the larger bench. Now, petitioners say in this particular case is Sibal argued that there is no requirement to examine the validity of 1981 amendment. If Aziz Basha is upheld, then the amendment will be considered along with the Allahabad High Court decision by a smaller bench. He also argued the court to decide if the union has the option to not defend the amendment despite being constitutionally obligated to do so. So now, respondent here says that Tushar Mehta argued that the 7 bench should be considered in this case to avoid multiple hearing on the same subject. He also stated that the petitioners see the 1981 amendment as a second chance to make a case for AMU minority status. This led to an exchange between CJI Chandrachud and Mehta, where Chief Justice questioned how the government could choose not to support an amendment enacted by Parliament. Mehta replied that the Allahabad High Court decision gave the central government ground to stand out to make this argument, and further stated that it was his constitutional duty to answer a constitutional question correctly. Senior advocate Neeraj Kishan Kaul later argued that Parliament tried to use the 1981 amendment to override the court finding in Aziz Basha, which is impermissible according to the previous Supreme Court judgment. So this is all about the case where, the decision is yet to come that AMU holds the minority, status or not. In this, the court will also consider Aziz Basha case. There were three major issues which we have discussed, and I hope this serves the purpose. Now, 37th International Surajkund Mela 2024. President Draupadi Murmu on Friday inaugurated the Surajkund International Crafts Mela 2024 in Haryana, Surajkund, which opened to the public. Organized by Haryana Tourism Department, the colorful festival that brings the artisans and craftsmen from across the country under one venue promises an unforgettable experience in its 37th edition this year. The Mela has become a prominent venue to showcase India's cultural diversity and rich heritage. Tanzania is the partner nation for this year to Surajkund International Crafts Mela, while Gujarat is the theme state. Okay. Now, Pradhan launches Ministry of Education and AICTE Investor Network for Innovation and Entrepreneurship in Education. So, Dharmendra Pradhan, who is the Union Minister of Education and Skill Development, has launched, and it is there to encourage the entrepreneurship and innovation in the education sector. The investment network also aims to bridge the gap between investors and transformative educational initiatives, fostering collaboration for the advancement of education and technology. Indian Navy to induct survey vessel Sandhayak in Vizag on Saturday. So Indian Navy is all set to commission its latest survey vessel Sandhayak in Vizag, and the ship is expected to boost the force surveillance apparatus in the strategic waterways. Sandhayak was delivered to the Indian Navy on December 4 after completing a rigorous and comprehensive trial program both in the harbour and in the sea. Indian Coast Guard celebrates 48th Racing Day. So Indian Coast Guard has celebrated 48th Racing Day on February 1st, commemorating its remarkable journey from a modest beginning in 1977 to becoming a formidable force in maritime security. Under the motto, Vayam Raksham Maha, we protect, the ICG has saved over 11,000 plus lives since its inception, including 200 lives in the year 2023. So Indian Coast Guard celebrates 48th Racing Day, which is celebrated on 1st of February 2024. Champai Soren sworn in as a Jharkhand CM, ex-CM Hemant Soren remanded to 5 days of ED custody. Jharkhand Mukti Morcha leader Champai Soren took oath as a 12th Chief Minister of Jharkhand. Even as his predecessor, Hemant Soren was remanded to 5 days in the custody of Enforcement Directorate. Rashtriya Janata Dal MLA Satyanand Bhokta and Congress MLA Alamgir Alam also took oath as a cabinet minister. Soon after the ceremony, 39 MLAs of the ruling coalition who have been staying in Ranchi Circuit House were rushed straight to the airport and flown to Hyderabad in a bid to prevent them from being poached by the opposition before the new government seeks to vote of confidence. The JMM-led alliance has submitted support letters from 47 LMAs to the Raj Bhavan. Tamil actor Vijay launches political party, names it Tamilaga Vetri Kazhagam. Leading Tamil actor Vijay has announced the launch of his political party, naming the organization Tamiz Haga Vetri Kazhagam. The name loosely translates to Tamil Nadu Victory Party. The 49-year-old actor also confirmed that he will contest the 2026 assembly polls in Tamil Nadu. Now, let us discuss some interesting facts about Tamil Nadu. It's the southernmost part of the state of India, the 10th largest Indian state by area and 6th largest by population. Capital is Chennai. Governor Shri R.N. Ravi. Chief Minister Shri M.K. Stalin. Language Tamil and flower Gloriosa Lily. Men's FIH Hockey World Cup 2024. India finished fifth, falling 6-4 victory over Egypt. So India finished 5th in Men's FIS Hockey World Cup 2024. Kenya finished 7th. Now, the 5th place is in India, 6th Egypt, 7th Kenya, 8th Tobago and Trinidad, 9th Pakistan and 12th, and 10th is Switzerland. Cabinet approves bilateral investment treaty with UAE. The government has approved the signing and ratification of a bilateral investment treaty between India and UAE. The treaty is expected to improve the confidence of investors, especially large investors, resulting in an increase in foreign investment and overseas direct investment opportunity. The pact would help promote investment between two countries. India received an FDI of USD 16.7 billion between 2000 to 2023. South Africa says 5 countries confirmed they are joining BRICS. So Egypt, Ethiopia, Iran, Saudi Arabia, and United Arab Emirates have confirmed that they are joining the BRICS bloc after being invited last year. The 5 countries were extended invitations along with Argentina at a summit in August in Johannesburg to join the bloc comprising Brazil, Russia, China, India, and South Africa. Argentina has since declined the invitation to join. Now, let us understand BRICS was founded on 16th June 2029. Founders were Russia, China, India, and Brazil. Purpose was political and economical, and abbreviations is BRIC comprising Brazil, Russia, India, China, South Africa. Now, let us come to the legal update. When two clauses of a deed are repugnant, earlier clause will prevail over the later clause. So the court has said that if there is a repugnancy between the earlier and the later clause of a deed, whereby later clause destroys altogether the obligation created by earlier clause, then the later clause is to be rejected as repugnant to the earlier clause, and earlier clause will prevail. The case name is Bharat Sher Singh Kalsia versus State of Bihar and another. High Court under Section 482 CRPC should not decide whether debt in check dishonor case is time barred. So the court has reiterated that the proceeding under 138 of Negotiable Instruments Act, the question of whether the underlying debt is time barred is based on the evidence. Thus, High Court should not decide the same petition under Section 482 of CRPC. Now, the court has said that the question regarding the time-barred nature of the debt and liability proceeding under Negotiable Instrument Act is a mixed question of fact and law, and which ought not to be decided by the High Court exercising jurisdiction under Section 482 of CRPC. And the case name is Atamjeet Singh versus State and City of Delhi. Maintenance provision being welfare legislation need not to be construed to be proven beyond reasonable doubt. The Kerala High Court, where the court is talking about Section 125 CRPC, and the court said that it's a welfare legislation and they need not to be proven beyond the reasonable doubt as their criminal counterparts. Conduct of wife opposite party during a stay at a matrimonial house may not be the sole parameter to be considered before granting maintenance under 125 CRPC. Now, if you want to revise your previous TNA, do attempt the TNA quiz that is mentioned in the link of this particular video. Thank you so much for watching. Take good care of yourself.